Good morning. I just watched a Jon Masters video. Jon Masters' real name is not Jon Masters. He's another convict. Felon. You know, jailhouse lawyers love to give bad legal advice because it worked out so well for them, right? Someone's walking past me before I pull out. It's always good to pay attention to your surroundings. Anyway. So he plays a police body cam video. Police apparently roll up on a guy who just stopped. He's like, "What's up? We saw you driving around. Thought you might be drunk." The guy's like, "Well, I ain't drunk." So they start talking to him, right? It's never a good idea to start talking to the cops. Again, they're investigating you. They already said that they thought you were drunk. Are you going to go? Yeah, there you go. They already said they're investigating you, so why are you going to help them? And then they ask if he has any guns or paraphernalia or anything like that in the car. He's like, "Oh, go ahead and search." Yeah, wrong answer, right? Wrong answer. Well, anyway, towards the end of the video, one officer tells him you're free to go, and the next thing you know, the officer grabs him and says you're under arrest and starts putting cuffs on him, right? Oh, if the officer tells you you're free to go, then you should be free to go. Well, the officer can change his mind, especially considering they just found small baggies of what they thought were drugs packaged for sale, because they think everything is a drug package for sale. Because they're cops and they're looking for drugs packaged for sale. But it turns out that they were antibiotics to treat a spider bite that he had recently received, and he had just packaged them up individually for his ease of taking them. Anyway, when they go to grab his arms to cuff him up, he pulls away, and hence they start using force. They start using force because pulling away from the cops is resisting arrest. Generally speaking, your state laws may vary, but you can't pull away from the cops. You can't rip your arm away if the cop's trying to cuff it. You can't do it. That's resisting arrest. Now, this guy, since there was no underlying basis to arrest him, he did not end up getting charged with resisting arrest. You have to be arrested for something, generally speaking, to be charged with resisting arrest. It's not a standalone charge. So, congratulations to him for not catching a charge, but he still got tased and you know, all the general. He says he got punched. I don't know if he did or didn't, but at the end of the day, it goes back to my old shtick of don't resist arrest. I don't know if anybody recalls the video yesterday that Earl put out where the lawyer got arrested. She did not resist arrest. She also didn't get tased, punched, beat up. In fact, I don't know of any video ever of a lawyer getting arrested, when the lawyer's sober anyway, where the lawyer resists arrest. Why? Because it is not a good idea to resist arrest. There's nothing to gain from it. Anyway, so Jon Masters goes on to say that you have a right. Oh, for all the cop lovers out there, for all the bootlickers, he says you have a right to resist arrest. And then he reads John Bad Elk. Now, I've done multiple videos on this. I think one is called Don't Resist Arrest in Texas. The other is called Bad Elk is Bad Law. And there's a reason for it. But you don't even have to talk to a lawyer. You don't even have to talk to a lawyer to realize that bad elk is bad law. If you simply go to the wiki page, Plummer v. State, John Bad Elk are both internet memes. They're both memes. They are completely inapplicable in today's world. Number one, because Plummer v. State was an Indiana Supreme Court decision back in the 1800s, early 1800s. And things have changed since then. And John Bad Elk, again, was from the early 1800s. And there are reasons why lawyers actually read all the cases that they cite in their briefs, or they should. Because you could look at the facts in John Bad Elk, and you could understand why it is no longer good law. Number one, the court was trying to figure out what law to use. John Bad Elk was on Indian territory. That is how the federal courts got a hold of it. State law enforcement officers who don't have jurisdiction on Indian territory came onto Indian territory to arrest John Bad Elk. John Bad Elk shot back. I think he killed some of them. Maybe did, maybe didn't. I don't really remember. I don't really care. But there was no statutory framework of law in place in that Indian territory. The court had to grapple with, how do we deal with this? And so what the court did is the court relied on just basic common law principles. Because there was no statute in place, they relied on pure common law. And they said, okay, under the common law, since there is no statute in place, there is a right to defend yourself on Indian territory, on federal lands where there is no other statute in place. Now, most federal lands, enclaves, will adopt the laws surrounding them. So if there's a military base in California, federal law applies. If there's no federal law on point, California law applies. Easy peasy lemon squeezy. So now there is an actual code of federal regulations that deal with, they created a penal code for Indian territory. It's 25 CFR something. So there is now statutory codes for Indian territory, and Bad Elk is no longer good law. There is now no longer common law available. You got to go by the statutes. The statutes don't allow you to resist arrest. Ergo, that holding is useless. I think it was in, I think the videos that I made, they came up around the time of Padilla's initial arrest. Or no, he had talked to it in one of his videos. Padilla asked a police officer if he had a right to resist arrest, unlawful arrest. And the police officer said no. And the police officer was correct, because in Texas, there is a statute specifically on point that says you can't resist even an unlawful arrest. You can't do it. There's a tiny exception in Texas law if the police are using unreasonable force before you start resisting. And remember, just pulling away is resisting. So, I mean, basically, if you do anything that prevents them from hooking you up, you've already lost if they come in, they start punching you before they try to arrest you, you can resist. I don't recommend it. I do not recommend it, but you technically have a right to resist. Now, here's my problem with Jon Masters, who is, again, not Jon Masters, and he's a convicted felon, and he's not an attorney, telling people that they have a right to resist based on a single Supreme Court case and a single Indiana Supreme Court case from the early 1800s. You didn't do your basic research, and people can get hurt. At the end of the day, the guy in the video that Jon Masters is reviewing resisted arrest. He got hurt. He got tased. According to him, he got punched. He got hurt. He's suing over it now because he got hurt. If you don't want to get hurt, don't resist arrest. And if you think he's going to win, I mean, they may settle if he settles for a low enough number that it's worth it for him to not go to court. But he resisted. He pulled away. I mean, you could see it in the video. The cops started to hook him up, and the guy pulls his right arm away. That's resisting arrest. And it doesn't matter. It doesn't matter that the drugs that they found in the car were legal. It doesn't matter. The cop had probable cause at that point to hook him up. Anyway. So yeah, resisting arrest. And I know I'm gonna get a flood of idiots in my comments. You have a right. It's a natural human right. At the end of the day, if you don't see attorneys doing it, you might pause to consider the ground that you're standing on, whether it's legal or not. You might pause to consider it. You probably don't have a right to do it. You're probably not going to get hurt unless you do it. If you don't resist arrest, you're probably not going to get hurt. There's a reason why the videos where people do get hurt cause so much outrage. That's why they go viral. It's because it's not common and it's not supposed to happen. And those people are going to get a fat paycheck if you don't resist and you get your ass beat. Oh, baby. Come find me. We will make a beautiful case together and we'll both get paid. But if you resist, it's, all bets are off. Anyway, I've beat this horse long past its death. I'll throw a couple links down to those two videos that I did on bad elk. You can actually see that LexisNexis shows that bad elk has been overturned by statute and by case law. I think in the Fifth Circuit, the seminal case that overturned bad elk was I think it was called Villafranca. I think it was Villafranca in the Fifth Circuit. And I don't know if that was before the 5th and the 11th split, but that's the case. I mean, it says expressly in there that those do not apply. Texas has a statute on it. Now, those are completely inapplicable, and every state that I'm aware of has statute on it, or at least their own laws on it. The federal government does not give you a constitutional right. The Constitution does not give you a right to self-defense against unlawful arrest. It does not. People have tried to make arguments out of the 8th, 9th, and 14th Amendments saying that there is not. You can go to your local law library and look it up. There is no constitutional right to self-defense. And since there is no constitutional right to self-defense and there is no federal statute stating that a citizen has a right to self-defense against unlawful arrest in states, because I believe that would be overstepping their bounds. I don't believe there's a constitutional provision for the federal government to make such a regulation or a statute. But it's citing Supreme Court cases is useless. It is immaterial. The question is, does the state allow it, either through the state constitution or the state statute? If yes, then you're fine. If no, then it doesn't matter what the Supreme Court says. It's not a federal question. So thanks for watching. Have a great morning.